their will, their legacy. Thank you, Ma, for recording. Be taken care of. And I think we have someone who we think is very, very qualified today to talk to us about this because this is his own field. And this is an area he has huge specialty. For us, we also think that this legacy asset management thing is trending and has always been trending, right? So whether you like it or not, every human being is really concerned about this. People spend time acquiring assets, people build mansions, people grow businesses, make investments, and people pay pensions, even insurance, life insurance and the rest. And people just want to know what is it that would happen to me by the time I become incapacitated and my resources are left behind. I tried to pull up a few data I wanted to just quickly hint as I introduce the speaker, which is around the United States. It says recent estate planning data from the United States shows that only about 24% of adults surveyed reported having a will, which is significant. And this is the United States. And then in Africa, we have understand that private wealth is also rising. And in 2025, Africa Wealth Report projects significant growth in the continent's millionaire population over the next decade. And we see in Nigeria here that 70% of Nigerians die without a will, according to PricewaterhouseCoopers projection. And this is significant, in terms of the number. And it's not surprising that we see a whole lot of problem when people die and the resources has to be divided because there's no clear guidance. And if we have any understanding of the scripture, Proverbs 13:22 says, a good man leaves an inheritance to his children's children. And we know what that means as Bible scholars. And so I just want to introduce Barrister Chiedu Aliogo, who is also a minister in the Transforming Church. But before we go into that, I just want to say we're privileged to be doing this on behalf of the church under the leadership of Reverend Dr. Sam Oye, who has given us this privilege to really talk about these things and do the things we do in the Covenant Keepers. And we're glad that we've received that grace to do this. And we just want to celebrate Papa and Mama for giving us this enablement. And Barrister Chiedu serves also under that platform, which is great. And though he sometimes shies away from it, he's a minister and also a pastor, because all of us are pastors. So Barrister Chiedu, we're glad to have you here. Our speaker, Barrister Chiedu Victor Aliogo, Esquire, is a seasoned legal practitioner with over 16 years of active experience in the legal profession. That's almost 2 decades. But beyond the years, what makes tonight's speaker very significant is the strength of depth that he possesses and the practicality of his legal mind. He's not just a lawyer in title, he's a practitioner who has helped individuals, businesses, and institutions navigate legal matters with clarity, structure, and strategic insight. His core areas of expertise include company law, and I've benefited from that expertise one way or the other. And I know a couple of persons in the church who has also benefited from that practice. He also has expertise in commercial law and in sports law. And through these areas, he has consistently provided sound legal solutions to a wide range of clients. He is the managing partner of Pearlheight Legal Practitioners, where he leads a dynamic team committed to excellence, innovation, and client-focused legal services. He is also a Notary Public member, which means he occupies a trusted legal role in the authentication, certification, and formal validation of documents in line with statutory and professional standards. I will summarize his profile by saying his work is marked by integrity, deep legal insight, and a practical approach to complex legal issues. And he holds a master's degree in law from the University of South Wales, United Kingdom, bringing both Nigerian legal experience and international academic exposure to his practice. Thank you so much, everyone joining us. The next voice you'll be hearing will be from Minister Barrister Chiedu Victor Aliogo Esquire, who will be taking us through this session, hopefully for the next 30, 35 minutes or 40 minutes. But please feel free, as always, to make this session very interactive. We realize that we gain a whole lot when we interact in this session. So I'll be handing the baton over to you, sir, as much as possible, take on and then lead us through while we come back with questions and interaction. Over to you, sir.
Okay, good evening, everybody. Such an interesting day, an interesting topic, a topic that a lot of people shy away from. Welcome. I see Pastor Sunday's wife. Welcome, Ma. It's an honor to have you here. Thank you for gracing us. Now, we are going to talk about, welcome, Ma. We're going to talk about, we're talking about wills, asset management, how of your loved one when you may no longer be here, or why you are even still here. You will see when they refer to some people as trust babies. When they refer to somebody as a trust baby, meaning whatever the person is living off has already been arranged somewhere. So it's a trust baby from a trust fund. He's doing whatever he's doing. He can decide to take trips 10 times in a year. It's not affecting anybody's account, but because something has been set up, that money is there for him to do what he wants to do. But we will start first with a will. And I know this is a very sensitive topic for a lot of people, particularly in this Jews. I'm not surprised at the statistics that Pastor Chiedu came out with. He got about Africa, that 70% of Nigerians die without a will. Now, what is a will? A will is just a simple testamentary document that a testator or an individual, who we now refer to as a testator for a male and a testatrix for a female, a document that they create how their property is going to be divided when they are no longer here. Now, that is different from a trust. A trust, the settlor can still be alive while the beneficiaries the benefit of the trust. But for a testator or for a will, the testator must have departed to the great beyond. And in that, under law, we say a will is ambulatory. Ambulatory means that it speaks from death. It cannot come into effect until the testator dies or the testator dies. I don't know, Pastor Chiedu, please help me read Hebrews chapter 9, verse 16 and 17, so that we will know that he will not.
Say that again.
I'll disconnect.
Say that again. Hello, sir.
Can you hear me?
I can hear you. I'm not sure I got what you said. You wanted me to read the scripture?
Yes, Hebrews chapter 9.
My Bible is not here with me. Does anyone have their Bible close to them? Okay, it's just probably somebody is supporting me here in my ministry. But if anybody have the Bible there, please help us. Okay, I think I've seen the Bible.
Okay, Hebrews 9, verse 16 and 17. I want to show us something there very quickly.
Hebrews 9. Anybody can help us out, please? Okay. Okay. 9 verse 25.
Hebrews 9, 16 and 17. Hebrews 9.
Okay. Okay. 16 and 17. Because a will is in force, NIV version, because a will is in force only when somebody has died, it never takes effect while the one who made it is living. This is why even the first covenant was not put into effect without blood. 19.
Exactly.
When Moses had proclaimed every command of the Lord to all the people, he took the blood of calves together with water, scarlet wool, and branches of hyssop, and sprinkled the scroll on all the people. Should I continue?
No, that's fine. That's fine. What I wanted to point out is in the case of a will, it is necessary to prove the death of one who made it. So, in other words, if you go back to what I said, that a will in law is ambulatory. In other words, it cannot begin to speak when the person is alive. It will always speak when the person is dead. Now, the Bible here now recognizes a will and is also telling you how a will becomes valid, how a will comes into effect, or how a will comes alive. Now, moving forward, it's interesting to know that people are always scared when you hear will. We are in a jurisdiction where, have you done your will? Say, hey, you put your hand over your head like that, like it's not my portion. The mindset of I shall live and not die, you know, a lot of us think that we have time here. Sometimes I always tell myself that Jesus Christ lived only 33 years. So you don't need to live the length of days to put things in place. And within the 3 years of his ministry, he had put everything in place for those to come and for those who will remain behind. The ultimate sacrifice he paid was a will. He created a will that you and I can come and give our life and begin to partake of the benefits and become beneficiaries of the will of another person. So as Christians, let's not shy away from that subject matter. I know I like to be very practical, and I'm going to delve into something, but I will be mute about certain information because of clients' confidentiality. Now, somebody in church had reached out to me, and we got talking. And like, sir, I want to do a will. I said, okay. When you are ready, let me know. We'll get it done. And he says, because he's married and he doesn't have children yet, and he's afraid that if anything happens to him, that his family will come and strip his wife of everything. So he wants to create a will to make sure she's adequately catered for if anything happens. Because he said in his mind, anything can happen at any time. And he has seen the way the family is towards his wife. But the fact that she does not have a child yet is already a concern. But that he wants to make sure he covers for her. And every time I kept waiting for this guy. So one day I reached out to like, Paddy, how far? You said you wanted to do something of this nature. He said, you're supposed to encourage me now. And you know, say it's difficult. He went back and began to think. So if I write this thing, I'm going to die. There was an apprehension of death. Writing a will is not an apprehension of death. Writing a will is that, the truth is that none of us will live here alive, except Christ. If Christ tarries, nobody's living here alive. So the idea that you think, if you are 100 years old, I don't think you even want to be here anymore, because your peers would have gone and you'll be lonely. So nobody is going to live forever. But while you want to check out, make sure that those who you are leaving behind are your loved ones who you know you have put things in place for. Till today, he has not come by. Every time I bring up that issue, say, I will get back to you. He has developed cold feet. And I know why. He's not the first person I've encountered when it comes to such matters. And let me say something. The very rich ones, or who we call the bourgeois, are not always afraid to create a will. That is from practice now what I have discovered. Those in the middle class, upper middle class, are the ones who we have experienced cold feet with. But the super rich that we have worked with as a lawyer, they will just tell you this is what we want to do. That day, everybody's ready and we get it done. You know. So moving forward, everybody has a right to do a will, provided you have the legal capacity. Now, 1 minute. In some traditions, A will does not take away certain things. You cannot use a will to divest certain properties or assets because you have a will. Yes, a will gives you room. A will is like your last instruction to the executors, please do this for me. Now going forward, in some traditions, like in Edo State, there's a tradition they call the Jugbe. It's called the Jugbe. The Jugbe basically means that if a man lives in a particular house and he has several other properties, but he lives in a particular house and dies without, even if he had a will and dies, that house, that property, no matter how massive the property is, belongs to the first son and him alone. It devolves automatically on the first son. Now, there is this very case that happened in Edo State where the testator, not the testator now, the man who died had, by a will, attempted to will the house that belongs to the first son to his side chick. He willed it, and the matter went to court. Even the courts, the law, that custom has become so notorious that the courts have taken cognizance of it and will enforce it. So whatever you decide to put that in a will, and so this is the last instruction, it becomes vitiated. That particular asset that you are trying to use a will to give to another person, the law will not even recognize it because custom has become so notorious that everybody knows that in this tradition, you do not give out the house where Baba lived and died to another person. It does not even go to his wife or to his second son. And that Ojobe in is the first son that has a right to it. The compound may be big, he can decide, oh, you go to the extreme, I give you that part, but that OB area belongs to the first son. Yes, you have a right to make a will, you have the testamentary capacity, you have sound mind, there are witnesses to it, there are executors to it, but there are some things that you cannot use a will to give away. Now, who can make a will? And what makes a will valid? The testator or the testatrix, as the case may be, must be of sound mind. Must not be a lunatic, must not be unduly influenced or make a will under duress, or must not be a minor. Somebody on a majority age in Nigeria now is 18. Somebody who is 17 plus cannot make a valid will because he's minor. So if you decide paper, it holds no water at the end of the day. Then what are the things that makes a will valid? After making a will, yes, you have a sound mind, you make a will. There must be witnesses who will sign, minimum of two witnesses that will sign in your presence. Thereafter, you proceed, the lawyer will proceed to lodge the will at the probate registry. At the probate registry, they will test of the soundness of the maker, the person who made this will. Is it sound? It's not for you to come and tell them that the person is of sound mind. They have their way of vetting that to know that, oh, the maker of this will was of sound mind, was of legal age, was not unduly influenced or under threat to his life, under duress when it was made. When that has been ascertained, you go ahead and lodge your will at the probate registry. You pay a certain amount as a fee, and it is registered and lodged. And it's until that man dies, and maybe after his burial, they unearth the will and read it to the hearing of everybody who probably is a beneficiary or an interested party that is bound to benefit. Now, something happened very recently, as recent as last week. Every time when I talk, I'll give you an example. My colleague in the office just lost her father, who is a senior advocate of Nigeria. He died. Today is Saturday. Monday will make it 2 weeks. And to the shock of everybody, they just called her. So she had to leave that very morning to Benin. While at the mortuary, the lawyer walks up, a lawyer just walks up holding documents in his hand and begins to say, in the mortuary, he has a will, he has a will. The body is not even cold yet. Now, even if that will was made when Leonard Silk was of sound mind, was not under duress of any kind, if that will goes through the tests of the courts, it will fall like a pack of cards. Because what is it will do in your hand? It's meant to be in the registry, duly filed. It was then one of the Baba told him to go and lodge this thing in the probate since he held on to it. Why he's holding on to it, we don't even know. If Pastor Chiedu, for instance, now you're a beneficiary of that will, or do you not challenge that will as an individual? You will that will, because it is not in the right place where it should be. So when the man died, it is possible that the lawyer could have altered that will. He may have included beneficiaries who are his allies, who the man may have removed as beneficiaries. So that is already a legal battle that is brewing while the man has not even been buried, because somebody did not do what they were supposed to do. And that amounts to professional negligence on the lawyer's part. We as lawyers, we hold a very sensitive position when we handle clients' instructions. It must be to the letter. A will has been done by a man. Apparently, he divorced his first wife, who had 4 children. He has another wife now, who probably has a couple of children. Then he had a third wife who didn't have a child. Now, as me and you are talking, trouble is brewing while we are gearing up for legal battles to come, because something was not done properly. So there is one thing for you to make a will. There's another for you to make sure that your instructions up to registry has been done. Otherwise, making a will and it is not filed appropriately is as good as not making a will. Praise the Lord. I'm remembering I'm talking to the body of Christ.
Hallelujah.
So another thing is that after making a will, you may acquire other properties. It's not every time you want to make a change, you go and destroy the first will you made. You can always, in normal English parlance, we say addendum. You can do an addendum to the main will itself. And that document is called a codicil. It's just an addendum to the main will. Maybe after you have made your will, you bought one property in Mitama, you bought another one in Mabushi, you bought in Kubwa, and it's not listed in that will. You now use a codicil to bring in those additional assets that you acquired after you have made that will. Where now you can also use a codicil to amend your will. Maybe one of your sons decided to do what one of David's sons did. And you now say, oh, because this boy has done this to me, I want to remove his name from this will. If the changes you are making to the will you made is going to be substantially affect the entire will, then it's only advisable you do a new will. But where you are making a will, just some minor adjustments here and there, you can then use a codicil to amend some certain sections and bring in new assets that may not have been included in the main will itself. Now, there's a difference between a will now and creating a trust. For a trust, Pastor Eva, you want to say something?
Pastor Eva is unmuted.
Like she wants to say something?
Not sure. That could be an error.
Not really. Barrister, please proceed. Ignore my kids here.
Okay. Okay. Now, for a trust basically is an equitable obligation binding on a person who is known as a trustee to deal with property for the benefit of another person known as the beneficiary. Trust arise where legal ownership is separated from beneficial ownership. So I may be the owner of, let's say, a plastic industry, and now create a trust. My trustees will now say, okay, part of what is coming from this plastic industry that goes into the trust account, my offsprings are the ones going to benefit from it. This is the ratio. They can decide as trustees to even invest some of those proceeds into viable businesses. Now, for a trust, the parties to a trust is one, the settlor. The settlor is the person who creates the trust. Then you have the trustee, the one who is the person to administer the trust on the part of the trust and the settlor himself. Then you have the beneficiaries, technically maybe your children. Now, a trust could be either express or implied. There's implied trust, there's express trust. Express trust is the one that the settlor by himself creates. Maybe, for example, now you have family trust, then you have educational trust. I know one time I had educational trust for my son, but because of what was coming in from the managers, the would-be trustees, I was not pleased, so I had to end it. Now, if you notice the difference between the trust now and a will is that I am alive and I can determine certain things about the trust. But for a will, no, I have no business in after making, I have no business. And it's until I exit or until the trustee and the testator exits, nobody knows anything that's inside that trust or inside the will. But for a trust, people can know, okay, this wasn't the trust. And I can at any time while I'm alive, create family trust, create education trust. I can also there are also some other charitable trusts. I can say, okay, I want to be sponsoring missionaries, and I create a trust for that. And I'm alive while funds or sponsorship is being given to these people. Then it will also be implied. Now, you can establish trust for public purpose. You can do for education, like I said, for religion, maybe you want to be supporting. I have an auntie who created the trust. All she does is to support missionaries. Once in a while, she'll call me, do you know any missionary anywhere? I was, okay, I know this person. Send me their details. She will always, from that trust, send money. Some people create trust to do poverty relief. Instead of registering their own NGO, they'll just create a trust for that. Then they can say, oh, we want to advance health. Oh, I don't like seeing people sick. They don't have money. We'll go ahead and create a trust for that. Now, what are the duties of a trustee? I know time is not our friend, so I'm trying to be fast. A trustee must act in good faith. He must not, because he's he holds a fiduciary position and must act in good faith. He must exercise reasonable care and skill. He must also keep accurate account. That is very important because once in a while, the settlor can request to see the books and see how things are being done. He must also avoid conflict of interest. If his interest conflicts with his instruction, then he may need to recuse himself. Then he must also at all times preserve the trust property. Is not to sell it for the benefit of himself. Then in distribution of assets, it must be according to the trust instrument that is set or has set out. For a will, you have executors. For a trust, you have the trustees. Now, what are the powers of a trustee? A trustee may invest the assets, the trust assets. He may sell, though with instruction, he cannot go overboard. He can decide to lease trust properties. He can appoint agents and authorize them. Then he also has the power where there is an adverse claim against a trust property. He can bring legal proceedings to defend the action. Advantages of a trust. You can protect the vulnerable beneficiaries, avoid probate. Now, this is where a will is different from a trust. One of the advantages of a trust over a will. There is a delay when it comes to probate issues. You have to come, because when the man dies, you have to apply for certain things. And there is attendant delay from courts. Probate have their procedures. You must follow the procedure to the latter. But for a trust, because you just have one trustee, he's basically the one in charge, calling the shots. He can quickly eliminate delay and get things done. Then it provides confidentiality. But for a will that has been registered in probate, it is no longer confidential per se. Then for a trust, it facilitates wealth preservation. The trustee can manage in a way that the wealth is preserved, ensures continuity of asset management, then provide tax planning opportunities for the beneficiaries. But in as much as a trust has advantages, it has its own disadvantages. One of which is the cost of establishing and administering a trust is quite higher than just doing the will and having your lawyer deposit same at the registry in probate. Then there is potential abuse by trustees. We all know that the world lieth in wickedness. The Bible says that the heart of man is desperately wicked. Who can know it? A trustee may just be waiting for something to happen. For instance, now the settlor might be driving one day and an accident happened and he passes on. Because the trustee has so much power, he can decide to dispose some assets and say, oh, your father had given the instruction for us to dispose these assets. He may even be silent about new assets that were included in the trust that the beneficiaries are not even aware about. I know of a man who has an airline. He was a trustee for a wealthy man. And when the man passed on, he literally converted everything that is on the trust property to his personal assets. And the man is still alive till today. But for confidentiality, I won't mention his name. That is one of the disadvantages of having a trust over a will. So you would, as believers, prayerfully, you will determine whichever direction you want to go. Then there's also complexity about administration. Administering a trust is very complex. And if you don't meet there are regulatory compliances that the trustee must meet, otherwise you run into problem. But for a will that has been deposited, the thing will just sit there in their safe keeping place until it is triggered by the death of the trustee. Now, the distinction between a will and a trust. One is that a will is ambulatory. In other words, it does not come alive until the testator or the maker is dead. But for a trust, it can operate while the person is alive and when the person is also dead. So while you are alive, you can make amendments here and there as relates to the trust, then a will requires probate to be fully involved. For a trust, you can avoid probate. For a will, it is easily revoked. The family, the man or the woman, the testator or the testator, can wake up one morning and say, oh, this my niece that I was to give something, she has annoyed me. I'm no longer giving her. Or my children turned against me. I hereby revoke my will. But for a trust, it may be revocable, but more often than not, it is very difficult to revoke a trust once created. A will becomes a public document after probate, while a trust is generally a private arrangement. For wills, you have the executors. For probates, it is managed by trustees. Now, there are modern day issues that happen, which we also have to consider, where you have probably digital assets. Maybe we're in the era of crypto now. Some things may be lost. Then family disputes, customary law versus statutory law. I already explained the Ijogbe and the OB as against the statutory laid down law that a man can use a will to divest his assets the way he wants. But some customs are so powerful that they will not allow you do certain things. It is not in your will. Our forefathers did it this way. It must remain in that way. Like they will say in Igbo language, as it was in the beginning, now and ever. You cannot override that custom, provided that custom is not repugnant to natural justice, equity, and good conscience. Because the first son steps into the role of the head of the family, no matter his age, there are certain things that are his. When they give him, like my foster father, he had a will, and in his will, if I can remember, there's the main house where we all lived, like a two-story building. Then there's the house on the side where his mother was living. Now, he died before his mom died. In his will, he said, until his mother lives and dies, nobody should touch the apartment, the mother's apartment. And if the mother dies, his younger brother should stay there, and he gave a certain duration of the number of days or years the brother should stay there. Thereafter, he should vacate the place and go and get his own. But at the main house where we all grew up in remains a family house. So if you go to London, America, anywhere you go, you come to Delta State and you get to Agbo, you must come to that place and have a room to sleep. There's a caretaker who cleans the place, make sure that the place is okay. So anytime you travel, you don't come into town and say you are going to lodge in a hotel. For him, he has outlawed it. You cannot go to a hotel. This is the family house. You bring your bag, you go there and you stay. When you are going, the caretaker takes the key and you go back. If not, I know one of the sons who will have put up that property for sale. Since, but he made it a rule that nobody will sell that house. Are we still here?
Yes, we are, sir.
Yes, we are, sir.
Okay.
Can hear you clearly.
Now, what are the practical tips for you, my potential clients? Because I see you as potential clients. Maybe after this whole thing, a lot of you will now make up your mind and stop being afraid. It's not a death sentence. Making a will is not a death sentence. It's just that you want to do right by you. Now, before I even get to the practical tips, prepare a will early is one of the practical tips. Prepare it early so that if you want to change it, you can as well change it. Don't wait till you are feeble or some people have started losing their mental capacity. It's already fluctuating because it's a ground for that will to be challenged. Appoint trustworthy executors and trustees. Prayerfully appoint these people. Prayerfully appoint these people. Something happened today. I went to work. There's a client is trying to lease her event center somewhere in Maitama. And I prepared the lease agreement. And the lessee has been pushing us back and forth. I want you people to install this. I want this. And the owner, being a man of God, kept bending backwards, kept bending backwards, kept bending backwards. And she's only paying for the first year. We pay for the second year in about 6 months and pay for the remaining 3 years in 3 years' time. But here was I. While I was having a meeting, another person walked up to me and said, I will pay you the 5 years in full, running to over almost 200 million. Now, it would have been easy for me to say, oh, if they pay the 5 million for the 5 years in full, my legal fee will be above the roof. I can easily tell my client, because it is what I tell my client they will do. I tell my client, this lady has given us so much problem. Let's revoke this transaction with her. I have another person who is even willing to pay us the entire sum at one lump sum, and we'll just go and wait for the next 5 years, rather than coming back after 2 years to come and start asking this woman to pay the balance of 3 years. But what did I do? I said, no, I can't do that. Why did I say no? I said, yes, I would have made more money, but when I commit to my word, I commit to my word. It's not about the money, it's about the fear of God. Will I have made enough money to help me do 1 or 2 things? Yes, but also integrity. Your words should carry weight, that when you speak, you will, oh, we can hold him to his word. Some people will say, take my word to the bank. It means that they will say what they do and they will do what they say. And that is how I have fashioned my practice. I never put money ahead of my practice as a lawyer. And I always advise my clients. Sometimes my clients will always want to, the ones I manage properties for, they will say, oh, increase the rent. I will tell them, the economic situation is not looking so good. Why not reduce? These people are human beings. I say, is that what you feel? I say, yes, I think that is what should be done. Those are the characteristics you should look out for when you are picking your executors or your trustees. Then keep estate documents secure. Maybe your landed properties now. Always keep it secure so that you will not go and by a will or a trust, give out a property that somebody has stolen your document and has sold to a third party. It becomes a big legal battle when you are no longer here. There's a property on 69 Road here, very close, very massive land. It has a football pitch. It can take the size of 3 football pitches. That's to tell you how big that land is. Now, that land belongs to a man who has passed on now, and a supposed pastor who is supposed to be the trustee began to tell the children that your father sold the property to me, and the matter went to court. And they have been going back and forth on that matter. Eventually, they decided to reach a mutual negotiation. And what was the negotiation? We will split the property into 2 halves. And they now filed that as their terms of settlement in court. Now, if it was a will, I don't think pastor would have been able to get away with 50% of the land size. If that land is valued in the market, imagine a property on 69 Road valued in the market, you are looking at a land worth over 10 billion naira as at today's market value. Now, that 10 billion would have been for the man's children, but it went to the wrong hand of a trustee who the settlor had trusted would do well by him. But if it was a will, that may not have happened, because it will have clearly been stated that this property belongs to me, I give it to XYZ persons. Then above all, always seek professional legal advice. Before you go ahead, after praying, you also do what is right. There's a place for prayer and there's a place for legal advice. Seek professional legal advice. Wills and trusts remain indispensable instruments in estate planning. Properly drafted estate planning documents minimize disputes, preserve wealth, ensure that wishes of the deceased or the settlor is effectively carried out. So it is essential, people of God, that at all times we should do right by our children. Every day I look at my son now and see that he's almost as tall as me. And like, this boy that I had which day here, and I'm beginning to see a whole lot. Like, if this boy grows up and leaves this house now, I will miss him. A lot is playing through my head. So what if I'm not here tomorrow? What happens to him? He now becomes the head of the family. Have I made adequate arrangements? Peradventure, something happens tomorrow. But you find out that to a large extent, lawyers rarely make wills for themselves. I will tell you the truth. They rarely make will. One of the very popular cases is Rotimi Williams. He's a very big lawyer for that matter. They call him Timi the Law. That's how vast he was. He's one person who handled a case and he was on this side of the divide. And on that side of the divide, he won the case at the trial court. On appeal, the other people reached out to him. He went on appeal and won for the other side on appeal. That is how good he was. But despite that, he died without a will. And two of his sons are senior advocates who have been battling themselves till date as me and you are talking. One of their brother that managed their farm, they have a farm. He has been the one managing the farm ab initio. Now I try to file some changes. I had to do some regulatory compliances for him so that he will bring in his own children into the farm. They refused to approve the documents for me in CAC because CAC knows that, oh, this family is a very notorious family. We know that their litigations are bound. We don't want to approve it for you. So one of the children will now come over and say, oh, the farm is part of their inheritance. That until we bring a judgment of court where all the parties are present, they will never approve that application. Until date, I have not been able to get the application approved. I've gotten back to Baba, and Baba is almost approaching 80 now. And that has still not been settled. But if his father, who has passed on, had created a will and said, Ade, the farm belongs to you, Ade would have been, it would have been easy for Ade to pass it down to his children. I will bring his children into the company. Till date, I've not been able to make his children directors and shareholders. And it's that bad. And the farm is so big that it can feed the entire FCT. But we're at a fix, and Baba is aging every day. His health is failing. But because somebody didn't do, his father now did not do something right, it's going to affect the grandchildren. So in closing, I have said so much, and I try to be as practical as possible. Currently, I have these two young girls who I applied for letter of administration for. One is 28, one is 26. They are both sisters. Their parents, their father died when the first one was 4. Their mom died when she was 8, 4 years interval. And what happened next is that the father's siblings took over all their properties in Lagos and sold it and migrated the children to the village in Edo State, in Ubiaja. And they were there going to farm, going to market to sell chickens, and eventually one got admission into university. The other one had to wait for the other one to finish. She had to do menial jobs like wash clothes for people so that she will survive. Sometimes she had to work in fast food restaurants as a student. but eventually she finished, served. So in the process of coming to serve in Abuja, I got to meet her, and like we now discovered that their father has shares in about 18 companies. And if they had known on time, before the federal government took over some of those shares that were unclaimed for years, they probably would have been multi-millionaires as we speak. But the government in 2023 took over a lot of unclaimed shares. So I don't know what is left now of the remaining shares. Then 5 of those companies have gone under. So the ones remaining now is what we are trying to salvage. Let's see what has accrued and what they can make of the rest of it. If there was a will, the children would have known that our father had shares. How did they know that these shares existed? It was because a cousin of theirs told them, let us go and check the SEC portal for unclaimed dividend. Daddy used to buy shares. This was their cousin who used to live with them, who was much older. And that's why they saw the father's name. All along for over 20 years of their life, they did not know that daddy had shares that would have made life better for them. The only properties they had, their uncles and aunties sold and shared money. The younger one is about to graduate nursing. She's doing her final, they have done their exam. I don't know the other things they do as nurses. I have had to support with school fees at some point. And in processing what I'm processing for them at probate, I've largely used 70% of my money to do it. Why am I doing it? For the face of humanity. They have suffered enough. Now, if the right things had been done, daddy did not know he was going to die, but if daddy had put plans in place, the children would not have suffered for almost 20 years plus. So whether a will, whether a trust, if you are so afraid that you don't want to do a will, you can do a trust. Either one may suffice, but weigh the pros and the cons, and may God guide you as you make progress. Thank you very much. Pastor Chiedu, over to you.
Wow. I've just been typing and typing. It's really interesting, so much that we don't know. I'm really excited about this edition because we have Honorable Justice Olukayode Adeni joining us today, Jesse Justice of the Court of Appeal. We're so pleased to have you on this call. And we're not surprised because of the kind of topic we're treating today. But thank you so much, Barrister Chiedu. This is really profound. Honestly, I've just been taking a whole lot of notes. I thought I knew so much, but I'm quite unlearned. So thank you so much, sir. I think we enjoy the practicality and the examples that you're able to provide to the conversation. You know, it's one thing to talk about these things in abstract. It's another thing to really bring it home by sharing relevant examples, relevant experiences that drives the point home. So thank you so very much, sir. I think at this point, I'm already seeing 2 hands. We'll open the floor for people to ask questions, bring perspectives, your own experiences and examples to the conversation. I've noted 2 or 3. I've noted 2 or 3 areas I also want to seek clarity on, because these are very controversial issues, especially the different complexities of which law is applicable. And I think you did touch on that. But Daddy, Honorable Justice, at any point in time, sir, please, we can be guided by your experience and by your expertise. But I think I'll go with sir.
My Lord will guide us.
My Lord will guide us. Oh, thank you so much, sir. I think we'll go straight to Pastor Olufumbi Adebamiro, and then we come back to Madam Ebun for the question. So over to you, Pastor, and hope Canada is a bit warm this time and not very cold. Well, over to you, ma'am.
Yeah, Canada is very hot right now. Okay, thank you very much. Yeah, it's hot. Thank you. I particularly was interested in this topic because I had an experience years back when I lost my mom. And when my mother died, she died intestate, right?
Yes.
Barrister, I hope I'm right. Yeah, meaning she died without a will.
Yes. Yes. Yes.
However, before she passed on, she was able to articulate everything, how she wanted her gratuity to be shared, whatever properties she had and the monies left in her account. But then my father writing them down was not going to take any effect unless we went through the court. So I had to travel down a couple of times. We had to go through the court to get statements from the bank, and you know how all these things are done. There was something I noticed when I went to the court. There were so many piled up files. And that was because people who had millions in their accounts, their families could not access them because they died without will. And they were required to pay 10% as upfront of whatever monies the deceased left behind. Now, a lot of them had young children who were not even old enough to work or something to raise the money. So a lot was left. I don't know what the new rule is saying now, but that was what I observed. Now, in the event that that happens, what should the family do? That is number one. Secondly, there's always the statement of, some people don't write will because they feel they are not wealthy yet, or they don't have sufficient assets to leave behind. Now, does it mean that it's only assets that can be left behind? Because people say that, see, no matter what you have, even if it's just the furniture in your living room, even if it's just the kettle that you have, will everything. It will shock you how petty people can get after you die, even as much as your phone. So, is it true that people can, it's not only assets like maybe houses, businesses, landed properties, can you also will all those little things out? I had an experience with my mom because when she was mentioning things to be shared, she only concentrated on the bigger issues, which were the houses, the money she had in her account, and blah, blah, blah. But after she passed away, after the burial, I was to leave and return to Abuja. And I had to now share clothes. Do you know that things as much as her clothing caused issues between her sisters? Now, I didn't have any issues because I wasn't going to be needing a lot of them. Or she already told me to pick the ones I needed to pick before she passed on. But she now had some of these are expensive George and everything. Now that began to cause issues and rifts between her sisters and her brother's wife. But that wasn't my business anyway. So I'm just trying to ask as a question. Do you also have to, does it hold water to include all these things that we might consider insignificant in your will to eliminate every possibility of people getting petty and, the likes? That's my
Okay.
question.
My lord is raising his hand. I cannot speak when my lord's hand is up,
I,
so that I will
I,
not.
absolutely. I didn't want to interrupt, Pastor.
My
My
lord.
Lord, sir, please come
Yeah.
in, sir. Sorry for keeping your hand suspended for a while.
Good
Let
good
me know.
evening. Good evening, everybody. I hope you can hear me.
We can hear you,
Yes, sir.
sir.
Yes, sir.
Oh, okay. Thank you. Thank you very much, Pastor Chinedu. Thank you, Chiedu, for a very insightful conversation. I think you have dealt essentially with basically the practical sides of making a will. It is important. Well, the essence of making a will is basically to make life easier for people that you will leave behind when you go. There is no point having properties which will be difficult for those who are supposed to be your beneficiaries, who have difficulty in having access to when you pass. I just have one
Good
or two
evening, sir.
contributions to make. Now, the first contribution is that I think Pastor Fumbi was asking about is the only properties you can make a will about. You can also make a will, even if you are not making a will about properties, you can make a will about how you like to be buried. Ordinarily, people may have informed their families ahead of time that this is the kind of burial I want. Some even go as far as making provision for monies to be spent at their burial and the kind of burial they want. So you can put this in a will and ask whoever you keep your will with to bring it out immediately after your decease so that your wishes can be complied with. Will is about making wishes post-death. But one of the easiest ways I think people should adopt in making wills is that you can make your will, you can divide your property even when you are alive. We call it gift inter vivos. For instance, if you have 2 or 3 properties, you can buy or transfer these properties to your children, to your wife, to whoever you desire to give it to while you are still alive. So that when you die, eventually, there will actually be nothing not much to deal with. And one of the reasons you want to do this is that when you pass and you have a lot of properties that you are willing to people, government has quite a large chunk of that, a large chunk of money that your beneficiaries will have to pay, even to access your properties. So instead of waiting for you to die, you can give your properties out while you are alive. After all, these properties are not going with you to wherever you are going to after death. So I use myself as an example. I have 1 or 2 or 3 properties here and there. I bought my properties in the name of my wife and my children. That's what I do. I don't have even as little as vehicles. I buy my vehicles in the name of my children because I know I'm not going to go away with these vehicles. And my prayer is that these people are going to survive me. So if they are going to survive me, why don't I do it in their name? So that once I leave, they just take over without any stress. And I'm saying this guidedly. It is only applicable in families where circumstances are very right. You must be able to trust your children and your wife to the extent that you know that if you pass properties to them in your lifetime, they will not tamper with it until you die. So what I've told my children is that, look, I have this, I put this in your name, I put this in your name, I put this in your name. But these are commercial properties. I'm going to be collecting my rent on these properties for as long as I live. But the moment I pass away, you take over. It is yours. The documents are in your name. So the rest that are not in their names, I will will it to my wife alone. And I give my wife the sole authority to decide what she wants to do with it. If I have monies in banks, I have shares in my names, I have that and that and that are still in my name, I will the entirety of everything to my wife. Then it is now up to my wife to decide what she wants to do with these things when I pass, believing that I will die before her. And then what people do is that what people also do is that if it happens, God forbid, that your spouse passes before you and you have already willed things to her, there is always, you must always put a clause in your will that in the event that my spouse passes before me, all the things I have willed to her will go either to my first child, who will have authority over these properties and deal with them the way he thinks fit. Other than that, you may, of course, you may want to give things to people you like. You want to give legacies, maybe to the church, to some associations, some other people, relatives, and all of that. My own suggestion will always be to reduce the number of your beneficiaries so that you don't create unnecessary problems, unnecessary contentions when you die. If my children know that everything I have is already belongs to them before I die, there won't be any agitations as to, oh, what's going to happen when this man passes away? How are we going to access his properties? How are we going to start running around getting a lawyer so what we are trying to do is that we want to run the likes of Chiedu out of business when we are still alive, so that they don't have much more to do. Give your properties to your offsprings while you are still alive. That is my counsel. Thank you very much.
Wow, that's
so
my.
much that is it.
Associate, go ahead.
Chiedu.
Yeah.
I mean, sorry, it wasn't me that said it. That we're so grateful for your intervention, sir. Thank you so very much. This is very practical. This is very real. There's a saying I picked up here: when a man leaves assets without instructions, he may leave wealth behind, but also leaves war behind. And I think I entirely agree with you. Most of the things I also either buy them in my wife's name or buy them in my wife and I name, because I'm in the development space and we have seen lots of issues, where people die and then properties are being dragged by relatives. And so early enough that they had adopted your method. Please go ahead, sir. Go ahead before I open the floor.
Right now,
Yes.
people who have money in bank now leave instructions. There's what you call POD, pay on death. They now leave that instruction that should, in case I pass, pay this person that comes to you. The person will present his ID card. You identify that this is the person named and pay. So the rigors of going to probate to make sure that happens is eliminated. So the person easily has access to the account almost immediately because of that instruction laid down. In as much as there are plans to run some of us out of business. So people now put that instruction on there. So Pastor Fumbi, as little as some of those things are, they cost problem. Now you have learned something that even the minutest of things that you may not really place value on is what people value. So if you have the room, like my father and I know that my father's compound in Delta, I know who has the apartment where he's living now. He says it every day. This one, I've given it to your younger brother. This large expanse is you and your elder brother. Whatever you want to do with it, go and do with it. So sometimes wills are informal. When I mean informal, it's not written. But he has told us, now that he's alive, I don't want that, okay, after I pass, you come and tell your brother to live here. This one belongs to him. This other part belongs to you people. And he said his family members know. So even if tomorrow somebody tries to be funny, his family members don't know this is the instruction that Baba put on ground. Like Justice rightly said, you just do some of these things, let everybody know, oh, this, and it becomes easier. But I know of a client's wife whose father, very wealthy guy in the East, in Enugu, has 3 boys and a girl. But apparently, there was a will the man had created, had properties. And the mother, I don't know the issue the couple had, and the mother turned the children against their father. The man quietly revoked his will, sold all the property he had, checked into a hotel, paid a funeral home for his burial, paid the hotel enough money that if I die, contact this funeral home to handle my funeral. Left an instruction for the brothers and the sisters. None of you should spend 1 naira. I have paid for my funeral. He now moved into a hotel. Obviously, in the hotel, he's not going to clean bedroom. He's not going to do anything. He's just to take his bath, go to the restaurant, eat. If he wants to go to the swimming pool, he will go out, come back. He moved out of the family house and moved to the hotel. And until he passed, and when he passed, some of the instructions that he had left, one morning, some people just came and said, this house was sold to us by Oga. These are the documents. Please move out. So they moved out the wife and the 4 children into the street. So these are some of the issues. But by and large, the man disposed of everything the way he wanted. Because he felt
this
it was terrible.
Wow, this is really interesting. And I can imagine if a document has this level of power, and I'm wondering why people are not using it, why people get these issues after their death, and everything is all confusion and but free for all fight. Thank you so much, sir. It's interesting. I think we'll come to Madame Ebon, and then
right?
Madame Ebon. Yes, I'm not sure I got the pronunciation.
I think.
Pastor, yeah, I think.
Good evening, everyone.
Good evening, madam.
Good evening, ma.
Much. Yes, I'm also so interested. I was actually going to ask of this gift deed, right? Is it gift deed or deed of gift?
You tell me just nomenclature, whichever way you is okay.
Yes. So my dad is, I don't know, of giving a will. And we were thinking, okay, if he does this gift method, if at all somebody else is pressuring him to do a will the will override the gift of deed? As if at all he will be 80 next year. So if at all somebody else makes him to change his will, if the deed of gift is already done, does the will come and cancel or alter that?
One of the characteristics of when you are to know that a will is valid, there must not be undue influence. So somebody influencing him to do a will it makes the will invalid already. If he's unduly influenced or is under duress. Because you are saying you just use the statement now that somebody is influencing him to change what he had given by a deed of gift. Then that does not make the will valid.
Okay.
He must not be unduly influenced in any way.
Because what I'm saying
Can
is
I
initially
also answer that question?
Yes, sir.
yes.
Can I answer that
My lord.
question?
Yes,
My lord, please comment, sir.
Okay, so if there is a if there is a deed of gift, and then the testator makes a will that seems to override the gift, of course, that will, to the extent of the gift, is incompetent, is invalid. Because once you have given a gift, you can't by will depose it again. Once you have made a deed of gift, that gift is gone in your lifetime. Like I was saying about me giving my children my properties when I'm alive. If I now go and make a will and then give the same properties to some other people, obviously I don't have authority over those properties again once I've already given them away. Once you have done a deed of gifts, giving your properties to someone, you can't now go and do a will on the same property. The only thing you can do a will on is to confirm. You can only confirm the gift. You can't override the gift. So the deed of gift is superior to the will. So that's my response to that.
Wow. Thank you so much, Daddy. Madam, hope that satisfies your question.
Perfect. Thank you so much, sir.
Thank you so much, Honorable Justice, sir. We're so grateful. I've also seen Daddy and Mommy Samuel on the call. Daddy and Mommy, at any point in time, please come into the conversation. Over to you. Is this Pastor Adiolu?
Pastor
I'm not sure. I'm seeing.
Is Pastor Adiolu?
Yes. Yeah, I hope so. Pastor Adiolu, please come in with your intervention. You have more clients now. Pastor, please unmute yourself and come in. Pastor Adiolo, if you can hear us, you can unmute and come in, please, except your hand was raised by mistake.
It doesn't seem to be answering. So, Pastor Chiedu, go ahead.
Yes, I mean, it's been an interesting conversation so far, and I'm learning a lot. And please, others at any point in time, please come in. Two key things that really worries me, and this is in the practical sense, you know. One of them is around family land, ancestral homes, and tribal custom, and how this overrides, you know, a whole lot. I mean, how they conflict and sometimes override even common sense. I will see a whole lot of time where people, even when they write a will over over ancestral home, the law can overrule that and say, oh, this is an ancestral home. It actually didn't belong to the man. He was inherited, or an ancestral property, you know. And it becomes really difficult to know what law will be applicable here, whether the ancestral law, the customary court law, or other aspects of the law, so statutory laws and the rest. And I will really want to get clarity on this. The second thing also in my head, which is related to this, is around the gender discrimination part of will and inheritances, especially against widows and female children. And we see this a whole lot of time, especially within the Igbos, where it is customary for inheritances to be willed most times. I mean, especially where there's no will, transferred to the male gender, as you've said, for example. I'm not sure I heard you say your daughter, your father has mentioned any of the daughters, you know. So it would be nice to really provide clarification around ancestral properties and how they are possessed, especially when there is no clear will, but also the gender discrimination aspect and what should be at play, you know, when there is no will and there are both gender involved on how properties can be inherited. And then thirdly, which I alluded to, is around which law becomes applicable. Okay, statutory law, customary law, family tradition, and some instances Islamic laws when there is when somebody have passed, especially when there is no clearly written will. It would be nice for you to touch on these three things and provide more clarity, especially for the audiences, the audience that will be listening to this after our conversation. Daddy, Honorable Justice, sir, please feel free at any point also to provide clarity. So over to you, Barrister Chiedu in the first instance, and then Honorable Justice comes in.
Bear with me, please. Hello. Sorry, bear with me for putting you in. I just wanted to quickly indicate, and I don't want to be distracted because I'm actually a bit distracted. There's somebody who has raised his hand, and probably that was the person you were thinking is Pastor Adiolu. It's not Pastor Adiolu. That's why the person did not respond. My own end here is OS. It's not Pastor
OS
Adiolu.
I saw, but the picture looked like Pastor Adiolu.
Good evening.
Oh,
good evening.
He has been waiting. Yes, thank you, sir.
Sorry, my name is Olivia. Can you hear me?
Go ahead. Go ahead, sir. There you know, sir.
Oh, okay. Thank you very much, Barrister Chiedu. Very insightful, very enlightening. I have two questions concerning someone who is late. Fortunately, had a will but unfortunately, there is some money in accounts. So what are the steps to take to access for the beneficiaries to access the accounts as well as shares?
Okay. If there are monies and shares, they will have to apply for a letter of administration. Basically, you approach a lawyer, the next of kins come forward, who are the next of kins, the beneficiaries, you fill out the form, it is submitted, you pay a certain amount of fee. For shares, the one I just had done recently, for the number of shares that were available, I was charged 7%, no, 2% of it. In some cases, if it's property, I think property goes as much as up to 10. So for shares and monies in account, you will write out those. There's the form they give you to fill. You write out the account numbers for the shares. You go to, if you have the share certificates, it's even easier. Where there are no share certificates, you have to get a stockbroker who will now do a universal search for you with CSCS, because CSCS will not attend to individuals except licensed stockbroker, or you are the owner of the share. But where you are not the owner of the share, it belongs to a deceased person. You now approach a stockbroker. You will pay, I think it's 1,000 per search, depending on the number of companies. They do a universal search. The system will spool the person's name and bring out all the shares the person has. Then they will print it out for you. You will attach it when you get to court that these are the number of shares. This is where the registrars that are holding them. It is now listed in part of what is going to be in the letter of administration that will be issued to you at the end of the day. You pay the necessary fees. You have to get 2 sureties who will also guarantee that peradventure you are lying, those sureties will be held liable. I have had to do that for some clients in some certain circumstances. Thereafter, the court now will write to the bank, let us know how much is in this person's account. The bank will now respond with the amount, and at the end of the day, the monies are remitted to the probate registry's account, and a check will be issued to you at the end of the day. That's for the monies in the account. But for the shares, I have gotten the letter of administration. What I now did was to proceed back to the stockbroker who took the letter, an application letter of now the administrators who have opened an estate account with any bank of your choice. Then the bank will now issue you another letter to CSCS that these are the administrators of these accounts. You take all those documents along with a copy of the letter of administration to the stockbroker, the asset management people. They will now proceed, open a file for you and file for you with CSCS. CSCS will now reach out to the registrars who are holding the money or holding the shares that this person has applied. Some registrars will now write and said the bank should write to them personally. 2 of the registrars of the 13 I was doing requested that the bank should write to them that these 2 people are the signatories to the account. When that is done, we have done that and we sent it back to the what they call them now, the asset management people, who now took it back to those registrars. So what we are waiting for now is the payment. That is what we are currently waiting for. So the payments will be paid into the estate account that we have opened. We open an estate account in the name of the deceased, but those to administer the account, who now become the administrators in the letter of administration, are the children or whoever ends up being the beneficiary. They are the ones that will administer the estate. That's for the shares now. But for the money in the bank, the monies will be remitted to the probate registry. Is the probate registry now issue you a check in that sum after their deductions? OS, does it make sense?
Okay, thank you very much. But already there is a letter of administration.
Okay.
There is something from the probate registry, but that only had to do with property.
Now you have to Because is it that you are not aware about the shares then, or you just became aware of about the shares now? Did you just become aware?
I think it was an oversight.
Because there's a column in that form you fill. There's a column when you talk about properties, you talk about other assets, then you not talk about shares in that form. So if it was an oversight, you can always go back to the registry to I don't know if my Lord can help me. There's they call it to do additional to cover for those shares. Otherwise, you will not get it. It will not be released. The CSCS will not order the registrar to release it without a letter of administration. And you must open an account. And without a letter of administration referring to those shares, you can't open an account with a bank. So you must go and request for another LOA concerning those shares. Otherwise, the money will remain there.
Right. Okay. Thank you very much. That's a lesson learned for future generations.
I like that true confession.
Yes, sir. Start with the female angle. Now there is a very popular authority now, Mojeku and Mojeku. It had to do with the female culture of now allowing the females to inherit. So now there's a law that allows female to inherit. In that scenario, in that case, I think the man died only having daughters, and his brothers came after the property that he doesn't have a male surviving child. So that the properties now devolves on them. And they went to court. And the court ruled that that custom and tradition is repugnant to natural justice, equity, and good conscience. And the matter from High Court went to Court of Appeal, and Court of Appeal affirmed the decision of the lower court. So women are now allowed to inherit in the East, as far as I know. And I also made mention of customary law and statutory law. I grew up in Edo State, so I saw this happen a lot. I'm from Delta, I've seen experiences. I also grew up in Enugu, I've seen Eastern experience. Now, premised on practice and things I've experienced firsthand, some customs, as far as they are not repugnant to natural justice, equity, and good conscience, how will you say because a man does not have male children, the daughters will not get anything? The court saw that this is not a good custom and overrode custom. But in Edo State, it is custom that cannot be overridden. The custom is so notorious that the courts have taken judicial notice that this is the position and the court will not override it because it is not repugnant. It is not bad for the first son to take over his father's house as the head of the family. So even if you attempt to use a will, a statutory document to divest your firstborn son of that property, the court will not the court will override it because that custom is so notorious that everybody knows. So you even attempting to do that is mischief on your part. You actually want to create problem by creating that will. Naturally, it would have been a smooth transition when the head of the family, the man where he lived and died, and he passes. The natural thing is that that property transfers automatically, even without anybody saying anything, to the first son. Attempting to use a will now to circumvent that position is you trying to create war when you have gone.
This is huge. I mean, for some of us.
Customs.
Can I come in here?
My Lord, please comment. I like the conversation.
I think I have a slightly different view from the barrister's view about some customs. Number one, it is what belongs to you that you can make a will over. This will also answer the ancestral property issue that Pastor Chiedu asked. Now, if a man has a first son, you are talking about some customs and traditions that have gained ground over the over the centuries and then becomes more or less like law. Where a man has a first son and he knows that his first son is irresponsible and he will not manage his property well if he dies, that man has a right to make a will, to dispossess that first son of his rights over his property. The property belongs to the man, whether it is in the east, whether it is in the west, anywhere. Once he makes a will and says, this property, it is my daughter that I'm giving it to, there is no custom that will override it. Once he makes a will, Barrister is talking about situations where the man leaves no will. If he leaves no will, the custom is that the first son takes over. But once he writes a will, which is his wish, this is how I want my property to be dealt with after I leave. No court of law will say, no, we have to change. No, your will is not. As long as it is his will, and the will is talking about his property, not family property, his own property that he acquired by his own money. If he has an irresponsible son, such a man will be more irresponsible to allow that son to take over his property because of tradition and culture. So that is the essence of will. It is his wish, and everybody must comply, including the courts, as long as the will is valid. On the issue of ancestral home, ancestral property, you call this ancestral. Once it is ancestral, it means it belongs to a community. It does not belong to a person. So no person has a right to make a will over an ancestral property. If it is jointly owned by a family or a community, the community will have representatives, or the family will have representatives who will decide what they will do with that property as time goes on. So no person will, in his right senses, go and make a will over a property that does not belong to him. Obviously, that will be invalid. You can only make a will over something that belongs to you, not somebody else's property, not a family property that is jointly owned with other people. So as far as the ancestral home is concerned, of course, traditional laws continue to rule how those properties are managed from generation to generation. And then you ask questions about Islamic law. Now, the same rule also where a Muslim, someone, maybe he married under Islamic law and dies, of course, the Islamic law of how their properties are shared will apply. But once he makes a will, there is nothing in our laws that says a Muslim cannot make a will. If you marry as a Muslim, or you don't marry, or you are a Muslim, and you choose to make a will and divide your properties the way you want, that is how you want it. It is only where there is no will that Islamic law will take over for those who marry under Islamic law or customary law. But once there is a will, that will overrides all this culture, all this tradition, overrides religion and everything like that. So that's how powerful a will can be. And I can, when Barrister Chiedu was talking about how difficult it is to have access to monies in the banks or shares in companies owned by a testator, or someone that dies, it comes back to what I had advised before. Can you please make life easier for your beneficiaries by making these transfers to them in your lifetime? Make transfers to them in your lifetime so that when you pass on, there won't be too much difficulty for them to access it. You know, I can buy shares in the name of my children, and I will tell them, come here. All the dividends that come from these shares belong to me when I'm still alive. But once I die, you can do whatever you want with it. We can have that arrangement. It makes life easier for them, you know. But putting everything in your name, when you know you are going to leave these things at the end of the day, of what benefit? God forbid there are emergencies in which you need to probably sell this or sell that out of emergency. But if all of those situations will not arise, and we don't pray they arise, it is always the easiest way. I still advocate that. The easiest way is to give gifts to your beneficiaries in your lifetime, so that there will be less for them to deal with when you go. In fact, some of them will be cursing you in your grave that this man just complicated everything for us. Why didn't he do this? Why didn't he do that before he died? Barrister was talking about the Rotimi Williams family. I mean, this is a controversy that has gone on over decades since the man died. Such an eminent lawyer who deliberately left his family. He has just 4 children from the same wife. It's not as if he's a polygamous man. 4 children from same wife, yet the 4 of them could not agree on how their father's property should be divided. That's how terrible it can be if we don't, make arrangements for our families before we pass. And we don't have to wait till we are old. We don't have to wait till we can do it today. You can improve on what you have done. You can change your mind tomorrow. You still have the opportunity to make changes, but do something just in case. Just do something. And for me, the easiest way to do it, especially for us who are Christians, can you just entrust everything with your wife, especially for us men? Can you entrust all your properties with your wife and let your wife be the one to decide what will happen when you pass? It makes life easier for her too, so that people will not come and your family will not start coming to harass her. If you don't want to give properties to your children, give everything to your wife. I don't buy, at my age, if I acquire new assets, I don't buy assets in my name again. It's either in my wife's name or my children's name. Good enough, they are all adults now, so they have the right to own properties. Once your children have rights to own properties, please put things in their names. Thank you.
Thank you, my lord. I'm not trying to, my lord, I'm not trying to dissent. It's not a dissenting opinion, but maybe when we have this conversation again or another day on the group, I will drop some write-ups that we can. So, peradventure, you are from Edo, Benin, because as far as I know, that decision about the first son getting the Ijogbe, the property where the man lived and died, has not been overturned. I will bring evidence to that effect. So if you are from Edo State and you are here, you are Benin, and you want to do otherwise, you are going to run into a brick wall. Once there is a court decision, until that decision has been overruled by the highest authority, it is still the law. And as far as I'm concerned, that decision of where the man lived and died, which is called the Ijogbe, and in the East, it's called the Obi, it has still not been overturned. My lord said something that you can use your property, your personal property, you can use your will because your son is irresponsible. When it has to do with that Obi or Ijogbe. Irrespective that that boy is irresponsible, the custom has become so notorious that all the cases that have come before the court that I know of and have read have always reversed that will or made that part of that will null and void, because the custom of the Bini people is that that house, no matter how terrible that boy is or would have been in his lifetime to his father, cannot go to anyone else except he passes on. And if he passes on, it devolves on his own first child. That has not been overruled till today. And maybe for this is these promise keepers, so that we will keep learning every day, I would adduce that evidence to support what I am saying.
I love this. Is the best session we've ever had. I mean, ever had. And I think because of also the legal perspective, but also from the fatherly counsel and all of the contribution and questions that we've experienced today. I am super, super grateful, Daddy, for having you on this call on behalf of Reverend Dr. Sam Oye and Pastor Mrs. Mary Oye. We're so grateful to have you here. Barrister Chiedu, we don't know how we can thank you. This is free consultation, no money, nothing. We don't know how.
It's not just free consultation, because I know there are potentials here who will reach out to me. In symbiosis, we are benefited which way?
But Daddy has advised otherwise. That we should do what? No, we should write a property.
Permit me to please come in at this point.
Come
please.
in, ma. After all, you're also a legal luminary. It's only us that are not learned. So come in, ma.
And maybe just to say that my colleague is not going to be at a disadvantage at any time. You can choose to buy property and utilize his services. I'm actually advertising for him, sir. So Barrister Chiedu, you should be proud of me. I am not in practice. I don't mind doing this for you, sir. You can utilize his services with respect to your document.
They should do it. And my Lord will really want to be feeding me.
No, so for instance, his lordship has bought property, and if he engages you, sir, to do his documents and all that, he will pay the percentage. So it's still a win-win. So we lawyers will never be disadvantaged in the mighty name of Jesus. Amen. I rest my case. Thank you, sir.
Thank you so very much, everyone. I think I will not want to end the call today without just recouching some of the beautiful words on marble or quotes that have been mentioned here today. And I think we're doing this also for the recording for those who will be watching and listening to it later. The first one here is, will is about making wishes post-death. Honorable Justice Olukayode Adeni JCA. And he went further to say you can also buy properties in the name of your children and wife to avoid unnecessary contentions after your death. And I think that really sits very well with all of us here. And same thing I do, buying properties in my wife's name and I. So we put Mr. and Mrs. I mean, we're say young. But of course, there are certain age we get to, it has to be in our wife's name. But thank you so much, Daddy. And I like the idea of pay on debts. That was very profound by Mr. Chiedu. That pay on instruction, where people can have that document or that legal access even while they are alive and give that instruction to their bank, before they die. And I did pick this quote: when a man leaves access without instruction, he may leave wealth behind, but also leaves war. And it's really important for us to clarify. I mean, the clarification today on trust and will is very important. And you gave a whole lot of practical tips, preparing a will early, appointing trustworthy, in fact, that's a quote, appoint trustworthy trustees. Barrister Chiedu. So appoint trustworthy trustees and executors. Keep estate documents secure. Keep professional advice. Seek professional advice. And Daddy said this one, and I noted that. It is only an irresponsible father that will will his son, that will will properties to his son, to an irresponsible son in the name of tradition. Daddy, thank you so much, sir. Honorable Justice JCA, in quote, you cannot will an ancestral property as it is collectively owned. That's also an important one. But I mean, I've written quite a whole lot here. Thank you so much. Oh, I see Barrister OJ's hand is up. Oh, okay, another legal mind. I'm coming quickly, sir, as we wrap up the conversation. Barrister OJ, over to you. Barrister OJ, if you're speaking, you just unmute yourself and so we can hear you. Barrister OJ, we can't hear you. We can't get any sound from you. Okay, I guess we'll just proceed. But just to say thank you so very much to everyone who has joined this call, especially our daddy and Honorable Justice in the house. Thank you so much. I see Pastor Dr. Oluyombo on the call. I see his amiable wife, Madam Joel Popola. I see Pastor Adewale on the call, of course, supporting our dearly beloved assistant coordinator. Pastor Lufumbi Adebamiro, our first lady in the TTC Gwarimpa. Thank you so much, ma. In diaspora. Thank you so much also, Madam Victor Aliogo, supporting Barrister Chiedu on this conversation. We're super grateful. Madam Mata is always on this call. So thank you. Deserves a round of applause. We're glad to have you here, ma. And then Madam Jane, as well as Mr. OS. I'm not sure I got that full meaning, but also good to have Mr. Abiola here. I'm not sure which of the Abiolas now. And then Barrister OJ on the call. Thank you so very much. Please, let's keep this conversation going on the platform. If you have any important thing that just resonates, please drop on the platform. People also need to hear these things. It is one thing for us to talk about them, and it's another thing for people to really reflect on them and apply them to their daily living. This will be me saying thank you so much, and wishing you all the very best, and see some of you tomorrow in church. God bless you all, and good night.
Thank you.